Ladies and gentlemen, thank you for taking the time to be with us today and welcome to the M&A Masters program and our first webinar of the year. My name is Kapish Mandyan and I'm a partner with the Corporate and Commercial Practice Group in Khaitan. I would like to extend a very warm welcome to this webinar to every one of you, whether you are in the audience, in India, around the world, or enjoying this webinar post facto as a recording. Without much further ado, I want to talk through today's agenda and what we constitute as the M&A Master Program. The M&A Master Program is designed to provide education and discussions on contemporary M&A issues to experienced M&A practitioners, including corporate executives, in-house legal teams, investment banks, and other intermediaries. Today, we want to walk through some case studies in restructuring, which we have experienced in the recent past. On this slide, we've set out the agenda. We'll talk through I'll give you a quick introduction of the topic. Our presenters will speak about the case studies. We'll thereafter open up the floor to audience questions. If you do have questions, please submit them using the facility provided in the webinar portal. If we cannot cover any questions that you have shared with us, please be rest assured we'll separately email you our responses after the webinar. Please also note that the copy of this presentation, along with the summary notes and a recording, will be sent to every one of you as a matter of course. To introduce our topic for today, corporate restructuring has emerged as one of the most strategic tools in the M&A landscape, enabling businesses to realign operations, unlock value, achieve tax efficiencies, and streamline group structures. In India, restructuring transactions, particularly through schemes of arrangements and amalgamations, have increasingly become sophisticated and complicated, requiring an expert analysis and understanding of the legal, regulatory, commercial, and other stakeholder considerations. Our panel here is adept at navigating through the plethora of regulatory hurdles that a scheme in India is forced to navigate. Today, we will examine how complex restructuring transactions are designed and executed through an analysis of two detailed case studies. Our presentation will predominantly focus on a scheme of arrangement between Tata Consumer, Tata Coffee, and one with TCNS and Aditya Birla. The discussion will focus on strategic objectives behind these restructurings, transaction structuring choices, regulatory approvals, valuation considerations, and key challenges. Just want to take a minute to introduce everyone to our esteemed panel here. Everyone has already received a copy of their impressive credentials before the meeting today, but I wanted to spend a quick minute introducing the two of them. We have Jimmy, who's a partner with our direct tax practice group. He's a chartered accountant and a lawyer, so he dual hats for us. He helps us on both sides of the aisle, as I can say. He has over 15 years of experience in advising on corporate income tax matters, restructuring, and regulatory matters. We also have Mehul, who is a partner with our corporate and commercial practice group. He heads our firm's restructuring practice. He has over 25 years of experience specializing in mergers and acquisitions, both solvent and insolvent restructurings, court-approved mergers, and insolvency processes. He's advised a plethora of domestic and international clients, including the Reliance Group, the Aditya Birla Group, the RPSG Group, Vedanta Group, Tata Group, and even international transactions with our German clients such as Siemens and Volkswagen. So without much further ado, over to you, Mehul and Jimmy, and we're looking forward to this webinar.
Thank you, Kapish. We'll spend the next 40 to 45 minutes on the two structures. And frankly, I would ask a question to myself, which a lot of you would have, that why these two structures? So let's look at structure one. If you look at composite scheme of arrangement between Tata Consumer Products Limited, Tata Coffee Limited, and Tata, the TCPL Beverage, 100% subsidiary of Tata Consumer Products Limited. The scheme basically entails a demerger of plantation business and subsidiary of Tata Consumer. And immediately thereafter, as an integral part of the scheme, Tata Coffee merges into Tata Consumer. Now, for both the transactions, for demerger and merger, it is Tata Consumer issuing its shares to the shareholders of Tata Coffee as consideration. Pursuant to this structure, upon demerger, unlike a classical demerger, where the resulting company in this, which is the TCPL Global Beverages, issuing its shares as a consideration, the consideration was discharged by Tata Consumer, the parent company of the resulting company. Now, take us to the structure two. Why this? This is a structure where Aditya Birla Fashions acquired majority control of TCNS Clothing Limited, followed by the merger. Now, one needs to understand and appreciate both these companies are were listed companies at the time when the scheme was announced. Pursuant to this structure, three tracks were announced on the same day. Share purchase agreement. There was a share purchase agreement between Aditya Birla Fashions and the promoters of TCNS Clothing to acquire the promoter control stake in TCNS Clothing Limited. Because it acquired majority stake and control stake as required under Takeover Code, a mandatory open offer or MTO by ABFRL under SEBI Takeover Code was announced. While the second step was mandated under the law to do it, it also announced merger of TCNS with ABFRL. Now, that's where it was a little different than what was done before, and therefore we thought, we would take these two different illustrations or different two cases as case study and discuss across for the next 40 to 45 minutes with you. Now, the question that one would have is, why would TCNS bundle all these announcement? Which we can of course discuss when we are going to discuss the structure, as in when we go. Next slide, please. Before we get into the mechanics and discuss what was undertaken pursuant to the scheme, it is necessary to understand the structure which existed before the effectiveness of the scheme. Now, I just want to spend a minute on this. Tata Consumer Products Limited is a consumer products company engaged in cultivation and manufacture and marketing of and distribution of like coffee, tea, ready to drink beverages. Tata Coffee, which is a subsidiary of Tata Consumer Products, which was a subsidiary of Tata Consumer Products. It had two businesses. One was instant coffee extraction business, which also had some branded business in it, and the second was the plantation business that it had. TCPL Beverages, which was again a wholly owned subsidiary of Tata Consumer Products, Products Limited, and it was incorporated just to hold the plantation business to this effect. Next slide. So, as I mentioned, they divided into two parts. Part one, a demerger of plantation business from Tata Coffee to Tata, TCPL Beverages, an issue of consideration by Tata Consumer to the shareholders of Tata Coffee, and merger of residual Tata Coffee with Tata Consumer Products, an issue of consideration by Tata Consumer to its shareholders, to the shareholders of Tata Coffee. Now, the shares held by consumers in Tata Coffee were cancelled as part of merger, and Tata Coffee was dissolved without winding up. Now, this is more so this structure which or the steps which were undertaken under the scheme. The nuance of the demerger, in this scheme was issue of shares by Tata Consumer instead of TCPL Beverages. Now, let's discuss that after we touch upon the merger part. I'm sure Jimmy is itching to speak on what is the nuance and how would you in that demerger, and therefore and we just want to touch on the merger part. Merger was a pretty simplistic merger. It was it was undertaken as part of as a consolidated scheme, and the consideration was discharged by Tata Consumer Products to the shareholders of Tata Coffee. Now, we need to understand that how this was a win-win situation for all the stakeholders. So before we jump on and discuss on the actual mechanics and the benefits out of this, let's touch upon let's spend a minute on the process. Now, since Tata Consumer and Tata Coffee both were listed companies, they were governed by the provisions of the SEBI circular dealing with the scheme related provisions. Now, the circular is issued under the provisions of SEBI LODR regulations. Because they are listed companies, the SEBI LODR regulations are applicable to them. In addition to the compliance under the SEBI circular, it was also necessary to comply the provisions of the Companies Act, that is Section 230 to 32 of the Companies Act. As required under the Companies Act as well as the SEBI circular, the consideration was required to be determined by a registered valuer. Additionally, the merchant banker was also required to issue its opinion on the fairness of the consideration that was discharged for the merger as well as demerger parts of the scheme. Additionally, as provided in Regulation 37 of the SEBI circular, before filing the scheme with the jurisdictional NCLTs, the listed companies are required to obtain a no observation letter from the stock exchanges on which it is listed. And is further, in terms of the Companies Act, the scheme was also required to be approved by the shareholders of each of the Tata Consumer as well as Tata Coffee. The scheme, because it was an arrangement between the promoter company and its subsidiary, in terms of SEBI circular, the transaction also required the majority of minority shareholders. Let's now look at what did the scheme achieve. If you were to look at from the scheme perspective, what did it actually achieve? At a very high level, this structure delivered two outcomes. One, a business ring fencing. The plantation business of Tata Coffee moved into a dedicated entity within the Tata Consumers Group. Now, as we discussed, it's a wholly owned subsidiary. In a demerger, generally, you would want to, the resulting company is required to issue shares to the shareholders of the company demerging into that company. However, this achieved a structure which generally one would want to take, execute into multiple steps to have a business sitting in the wholly owned subsidiary. Number two, it also was achieved a group simplification. Tata Coffee post demerger was then merged into Tata Consumer. As we looked at, both Tata Consumer and Tata Coffee both had a sort of a business which was which had synergies which they could maximize post consolidation, and therefore by consolidating this, it gave a platform to Tata Coffee shareholders to be part of a larger branded consumer products business, which had a multiple growth avenues, and at the same time, they will also continue and participate in the plantation business through the holding company, which is Tata Consumer Products Limited. Again, the benefit that one would have here, because this was implemented under the scheme, is that the stamp duty, you will be subjected to concessional stamp duty rates. It was not something what one would end up having the ad valorem or the stamp duty which otherwise is required to be paid on a conveyance, on a regular conveyance basis. It was also a tax neutral, which of course Jimmy is going to touch base why it qualifies to be a tax neutral transaction. And again, the structure adopted for undertaking the demerger is not very common. Unlike the traditional structures wherein a demerger will lead to a separate company, because there was a demerger happening from a listed company, this did not get listed. And in very, very few cases, this structure has been followed. Of course, in the past, you had schemes of NDTV, you've got a scheme by Thomas Cook, you've got Havells, there's a couple of them which are still on right now. So, while classical demergers have been followed on a regular basis, but schemes like NDTV, Thomas Cook, Havells have been very rarely, undertaken.
Now, coming from an income tax perspective as well, it's very important to see how does the income tax law really look at such schemes of arrangement, whether it's a demerger or a merger. As you all may be aware, income tax law has fairly old provisions now which deal with definitions of certain constituents of a scheme of arrangement, as well as the manner of tax neutrality which is to be accorded to such transactions and the conditionalities attached therewith. To start with, let's look at the demerger, which as Mehul rightly mentioned, is a unique aspect here in the present case. Let's take a step back and see what a classical demerger otherwise looks like, even from a tax perspective, and how the tax provisions really provide for that. So there are three key essential ingredients of a tax neutral demerger under the income tax law as well. One, you have a demerged company, which is essentially the company which gives away its undertaking. In our example, it would be Tata Coffee Limited. You would have a resulting company which would end up receiving the undertaking, which in our example would be TCPL Beverages Limited. And then in consideration of this demerger, the resulting company has to issue shares on a proportionate basis to the shareholders of the demerged company. So if we were to take this classical example here, it would have required TCPL Beverages Limited as the resulting company to issue shares to the shareholders of Tata Coffee Limited. Now, clearly, as Mehul has explained, that is now not how the scheme was implemented. And the question, therefore, which begs for our attention, even from a tax perspective, is that does it still remain tax neutral if a parent of such a company as TCPL Beverages, which in our facts is Tata Consumer, if it issues shares to the shareholders of the demerged company, does it still qualify as a tax neutral demerger? Which brings us to the core nuance here in the present facts. And it begs attention and examination of the definition of the term resulting company under the income tax law, because that is essentially where the beauty of this interpretation really lies. So if you were to read the definition of the resulting company, which is provided in section 241AA, it essentially says that a resulting company is one or more companies, including a wholly owned subsidiary thereof, to which the undertaking has been transferred from the demerged company and which issues shares to the shareholders of the demerged company. Clearly, when we try and apply this definition to our facts, we can agree that the law contemplates more than one resulting company, which now brings us to the point that if it can be more than one, then what are the situations under which we can consider two companies as resulting companies? So the definition says resulting company includes more than one company, including a wholly owned subsidiary thereof, which issues shares to the shareholders of the resulting company and to which the undertaking of the demerged company has been transferred. So to apply to our facts, could somebody on a very plain reading say that, you know what, if it includes a wholly owned subsidiary of the resulting company, then it should ideally be a resulting company of TCPL, which should be issuing shares if at all one was to consider two resulting companies, or alternatively, it should have always been TCPL Beverages to issue those shares. Now let's step back and also look at what would be the consequences of this commercially for the shareholders in such a case. I am a shareholder in Tata Coffee. An undertaking is going away from my investment into another company, which is Tata TCPL Beverages, and a third company altogether, which is a subsidiary of that company, issues its own shares to me. Clearly, from a commercial standpoint, the undertaking which really gave value to or a part of the value to Tata Coffee Limited has gone to company A, and a company B altogether ends up issuing shares. Clearly, that sounds absurd and will lead to a very absurd commercial outcome for the shareholders of the demerged company. Let's go back and see how else could we really try and interpret this definition of resulting company. Can we, for a moment, consider TCPL itself as the parent of TCPL Global Beverages as the resulting company, and therefore a resulting a wholly owned subsidiary of such a resulting company would therefore be TCPL Beverages. So you have resulting company 1, which is Tata Consumer Products Limited, and a wholly owned subsidiary of that, which is TCPL Beverages, becoming the wholly owned subsidiary and resulting company 2 in our facts, which receives the undertaking. To summarize, there is a tax neutrality possible, given that the company receiving the undertaking is resulting company 1, and the company issuing the shares to the shareholders of the demerged company is a 100% parent of such a company, and thereby the tax neutrality condition can still be said to be satisfied, and there should be no adverse tax consequences on such a demerger from Tata Coffee to TCPL Beverages, where shares are issued by the parent of TCPL Beverages. Coming to the second part of it, and which is relatively easier, the merger section. The merger of TCPL Beverages, Tata Coffee into Tata Consumer, essentially the base vanilla conditions of tax neutrality of the income tax law are that there should be transfer of all assets and liabilities, and shares should be issued on a to all the shareholders, or at least 3/4 of the shareholders of the amalgamating company. Those were simple conditions which were met in the present facts. Of course, there could be other nuances as well when it comes to amalgamation in terms of transfer of losses, whether there were losses in the first place or not, whether those entitlement of losses can still be carried forward to the amalgamated company. Income tax law, again, through section 72 and related rules, have detailed prescriptions about what kind of transactions and what are the conditions in terms of asset size, continuity of business between the amalgamating company and the amalgamated company, which can really allow or accord a carry forward of losses of the amalgamating company, if any, to the amalgamated company. Mehul, you are on mute.
Sorry, guys. To wrap up the structure one, the combination of a demerger into Tata Consumer subsidiary followed by a merger of Tata Coffee into Tata Consumer is a neat way to ring fence a business line and collapse the holding structure.
And the key takeaway from an income tax perspective is also very important to ensure and see that all the necessary conditions which are stipulated in the income tax law, it's necessary to ensure that all those conditions are met if one is aiming to target a tax neutral scheme of arrangement such as this. Next slide, please. Now let's consider a slight variation to the demerger section that we saw in the previous case study. There we saw that you had Tata Coffee demerging its undertaking to Tata Beverages, and Tata Consumer as the parent of beverages issuing its shares to the shareholders of Tata Coffee. This structure in a way is a spiritual evolution of the prior demerger structure, I would say, because here, as we can see on the screen, you had a company, Ajmera Realty, which had several business undertakings, and it also had a wholly owned subsidiary in the form of Radha Raman Dev Ventures Private Limited. Now, one of the undertakings of Ajmera Realty was a Project Vadala undertaking. Vadala is a place in Bombay. So there was a project at Vadala called the Vadala Project Undertaking, which Ajmera Realty essentially hived off or spun off under a scheme of demerger to its wholly owned subsidiary Radha Raman Dev Ventures Private Limited. And interestingly, in consideration, instead of Radha Raman Ventures Private Limited, Ajmera Realty itself issued its own shares to its existing shareholders on a nominal basis. Here, as we can see, that Ajmera Realty therefore wore two hats altogether. One is of a demerged company, which is essentially the company giving away its undertaking to the resulting company, which is Radha Raman Dev Ventures Private Limited. That is point one. And on top of that, it also wore the hat of being a resulting company too, which ends up issuing its own shares to the shareholders and thereby complying with the tax neutrality condition under the income tax law, which is enshrined in section 219 of the Act. So by doing a wholly owned subsidiary hive off as well, a tax neutrality was sought to be achieved between Ajmera shareholders as well as its wholly owned subsidiary in the form of Radha Raman Dev Ventures Private Limited. Now a question may arise that, you know what, if I'm a parent and I have a wholly owned subsidiary, why would I really want to undertake a scheme of demerger? Why not just transact with my subsidiary and be done with it? Do I really need to go to a third authority and a set of regulators, whether it's NCLT and several other stakeholders and regulators in the process, to undertake a transaction with my wholly owned subsidiary? Is it really mandated by law, or did it even have alternatives? Of course, there could have been a possible straightforward business transfer agreement between Ajmera and its wholly owned subsidiary. And interestingly, from an income tax standpoint as well, there is a exemption available from a capital gain standpoint as well as to the subsidiary from a receipt of business undertaking standpoint for such transactions. The only interesting aspect is that while the law accords an exemption to capital gains transactions with wholly owned subsidiaries, it comes with a rider that such a relationship of wholly owned subsidiary going forward should not be breached for 8 future years. Now, this can be quite a challenging condition commercially in case any value unlocking is really envisaged by post the hive off of such an undertaking. So that is something that may have possibly played a part in as to why a scheme of demerger may have to be undertaken for a transaction which may apparently look as simple as just a slump sale of business to its wholly owned subsidiary. Next slide, please.
So just to add here as well, that to plantation, the plantation business to the wholly owned subsidiary of TCPL. Then and it would have just merged. It would have had to then demerge or do a slum sale. It would have to do the second. It may have to do Ajmera if you were to get the plantation business down. So in a view, if you were to look at the Tata Consumer Product Scheme, it achieved both. It achieved the demerger as well as it achieved the requirement of holding the plantation business into its wholly owned subsidiary. As Jimmy explained, it was a tax neutral transaction for the shareholders. The shareholders continue to hold the interest in plantation business. Shareholders of Tata Coffee, of course, continue to hold the interest in plantation business through Tata Consumer Products, and at the same time, Tata Consumer Products could hold the plantation business as in its wholly owned subsidiary without diluting the interest in that company. Next slide, please. Now, with that, we'll move to the next structure. This is a structure, as we discussed, wherein Aditya Birla Fashions Retail acquired majority control of TCNS Clothing Limited, followed by the merger. Before we get into the mechanics and discuss what was undertaken pursuant to the three steps that were taken that day, it is necessary to understand the structure which existed before the transaction was undertaken. Aditya Birla Fashions Retail Limited is engaged in the business of manufacturing, marketing, sales, and distribution of fashion apparels, footwear, and accessories. And similarly, TCNS Clothing was also engaged in the business of manufacturing, distribution, sale of women apparel, jewelry, etc., etc. The promoters of TCNS held approximately 32% of TCNS, and it is to be noted that both the entities were listed at that point of time and also engaged in the similar line of business. Next slide. I would want to emphasize similar line of business because that's where ultimately we will be spending some time on it. So let's understand the steps that were undertaken on the announcement date. ABFRL effectively put out three connected legs, which were distinct actions from each other. The first leg was there was an announcement of SPA with the promoters of TCNS. ABFRL announced that it has signed a share purchase agreement with TCNS with the promoters of TCNS Clothing Limited to acquire entire approximately like 32% of the promoter control in TCNS Clothing. Because it acquired more than 26% shares under the takeover code, and it also acquired the control of it under the takeover code, it triggers the takeover code and sets the pathway to immediate management control subject to the conditions and closing. It also required to have a mandatory MTO announcement as required under the takeover code. ABFRL was required to immediately announce the mandatory open offer or the minimum tender offer. Accordingly, a mandatory open offer by ABFRL under the SEBI takeover code was announced. Now, what was announced in addition to this was the actual, I would say, the icing over the cake, which was the merger announcement. It basically took into consideration the nature of businesses both the parties undertook at the time when the transactions were announced. Both of them, like TCNS and ABFRL, announced the merger of TCNS with ABFRL, even though the merger would roughly take about 12 to 15 months to complete. Now, when this was done, prior to that, there was only one transaction. I think what I recollect was when Birlasoft and KPIT transaction was undertaken, a very similar structure was announced. Not exactly to the T of it, but something similar to that extent was announced. And thereafter, it was almost after 6 to 7 years of time, such a transaction was announced, which would take about 12 to 15 months to complete. Now, this transaction, if you were to ask us, was designed to deliver control now and full consolidation at a later stage. with the public shareholders receiving of TCNS receiving ABFRL shares at the end. Now, why this structure is distinctive, and why propose a merger? So, generally, one would, once the SPA closes, open offer runs its course, ABFRL would have achieved control over TCNS well before the merger, before it become effective. So, would it be, would it be healthy for the shareholders of both the companies to continue to operate a line of business which are very similar and almost competitive in nature? Now, during this period, the legal reality would be, what would be that reality? TCNS continues to remain. So I'm talking about the period that is after the MTO is completed, but the merger is yet to be done. And this is roughly about 10 to 12 months of time, which is going to be there. So during this period, the reality would be that TCNS continues to remain a separate listed company, which is, until the merger completion, etc. An acquirer, that is ABFRL, would have taken control over the board and management. And this is when the integration would start. Generally, the strategies, sourcing, distribution, back-end synergies, subject to governance, etc. Of course, the related party rules and minority protections, whichever would be there. But there would be some back and forth that would happen. Now, just imagine a situation that what would have happened if this merger would not have taken place. How would how would both ABFRL as a shareholder and TCNS as a company, and the board manage this situation? And therefore, it is necessary that the merger is actually something which was a must to have these two companies in the nature of business. And why is because only then you would actually see that you would create actual value for the shareholders of TCNS if the merger is not if the merger is undertaken. Now, between this 12-month phase, this is where we would generally say that lawyers or other consultants and teams, the auditors, including the secretarial teams, would actually come into action, and they would start discussing and putting out principles on governance and board composition. They would also bring in the related party transaction discipline. Why? Because at the end of the day, it would be a transaction between a parent and subsidiary. It's not a wholly owned subsidiary. Therefore, you would not get an exemption on related party transactions between both the companies. If there are any interim covenants, if there are anything undertaken during the SPA, one would want to complete that. There would be a lot of regulatory approvals and schemes, conditions which are required to be complied with both the companies independently, having independent boards. And of course, there will be disclosures alignment, which is required to be taken. What is actually to be said to the market at this stage, etc., at the time of announcement. With the merger, so what would, if I would ask a question, why announce a merger when, in addition to these complexities, why should I announce this merger now, and why not announce the merger at a later stage after the MTO is complete, or after the Aditya Birla Fashions would have, or ABFRL would have taken the control of the company? The way one would look at is that it ensures that the shareholders are equally informed, and thereby eliminating any ambiguity regarding future consolidation plans. So, why create this ambiguity? Qua TCNS shareholder, especially, would be looking at, would ABFRL actually, have equal attention on the company? Would they continue to, have the same line of business? Would they really think of us, our value creation in this company? So that and therefore by announcing this, it's very clearly creating, it eliminates the ambiguity between the shareholders, or in the minds of shareholders. It also discourages, as I said, conjectures or amongst the shareholders whether group will continue to have two listed companies or going forward. It also discourages speculative trading in the equity shares of the target company, which is which is TCNS, and due to the anticipated corporate restructuring activities, if at all one would think that they will have to do it at some point in time. And the most important is it enables the shareholders, which is the TCNS shareholders, to take a very informed decision on tendering the equity shares under the open offer, vis-a-vis continuing as a shareholder to participate in the growth story of the consolidated entity. Now, this I will want to spend some time here and would want to discuss why it is important, because from the tendering perspective. Now, when an open offer is announced, generally a price is it is announced on the basis of a price which is negotiated between acquirer and the seller, which is more often a negotiated price. In terms of SEBI takeover regulations, the MTO price, which is the open offer price to the public shareholders, is required to be the higher of the negotiated price or the formula provided, which is generally the weighted average price determined of the shares which are traded, that is TCNS shares which are traded on the stock exchanges. Now, if a merger was announced now or at a later stage, if it is announced on the same day, what it does is, in terms of the regulation, what we discussed during the Tata Coffee, Tata Consumer as well, that the share swap is required to be determined after following, is required to be determined by the valuers. Now, the SEBI circulars mandates valuers to determine the, share swap ratio after following various methodologies, which ultimately gives a clear indication of the arbitrage. Once the value is determined of the company for determining the share swap, it will lead to a clear arbitrage between the MTO pricing and the merger pricing. Say, for example, if the negotiated price, say the stock exchange traded price of TCNS was say 300 rupees, and negotiated price, because it was a controlled price, was say 280 rupees or 290 rupees. And for the determining of share swap, say the valuer would have determined 310 rupees or 350 rupees. Now, if this price was not disclosed on the day when the MTO was announced or when the open offer was on, the shareholders would have lost. They would not have realized that they could make more. They would be entitled to more shares in the merged entity or the consolidated entity if the value would. And therefore, it is necessary. It's a good move, and from a governance perspective, it becomes much more from if the MTO pricing is also available during the at the time when the MTO is announced.
So when one looks at this, even from a tax perspective, and Mehul has very beautifully articulated as to how, at some level, the shareholders of TCNS in particular would be at a crossroads of sorts. That look, do I tender my offers under the open offer, or do I continue being a shareholder of TCNS and eventually, therefore, receive shares of ABFRL as in pursuance of the merger? From an income tax perspective as well, the consequences can differ dramatically because at one level you have a MTO tender, and therefore you essentially are transferring your shares against monetary consideration. That has a separate capital gains tax impact. As an alternative to that, if I continue holding the shares of TCNS, the tax consequences can diverge materially, as we will see going forward.
Again, so once the MTO is announced, the MTO is complete, and then when the shareholder, one of the shareholders has a control, that is ABFRL has control over TCNS, and the scheme is in progress. The scheme is also subjected to the majority of minority requirement, as we spoke, because it's again going to be a transaction between a subsidiary and its promoter group. So therefore, TCNS was subjected to majority of minority shareholder approval as well. With as a part of this process, as a merger process, what would this mean? Ultimately, if you see on the right hand side of the slide, you see the end result or the resultant structure, whereby the shares held by ABFR and TCNS were cancelled, and the shareholders of the public shareholders especially were issued shares of ABFRL, whereby making them part of a larger shareholder, a larger group, a larger company with having larger base to the strategies, etc.
From a
Uh,
from an income tax perspective as well, now if we were to deep dive into the consequences for each set of shareholders, we have one set of shareholders who essentially tender the shares under the open offer. What would happen in that case? They'll essentially be selling the shares, receiving monetary consideration, and therefore it's a clear capital gains tax impact and an event for them on the date of the transfer of the shares of TCS Clothing. Now, interestingly, we have to remember that these shares are listed on a recognized stock exchange. So the period of holding, of course, is just 1 year if one were to consider it a long-term capital asset. On top of that, what is also important to remember is that listed shares which were held on 31st January 2018 enjoy what we call as grandfathering of cost basis under the income tax law. As many of us may recall, until 2018, there was no long-term capital gains tax on transfer of listed shares. 2018 was the year in which it was reintroduced after a very long time. And because transfers going forward are taxable, the law gave a relief in the form of accrual of gains up to January 2018. So essentially the law says that the fair market value of such a stock on 31st January 2018 is allowed as a cost basis for computing capital gains on transfers made thereafter, which essentially means that your gains up to January 2018 are really grandfathered. Similar implication would therefore have applied to shareholders of TCNS Clothing who would have tendered their shares under open offer. Now, what if I don't belong to this category? Then what happens is that as a shareholder of TCNS, I sit back and I end up receiving shares of ABFRL pursuant to the merger going forward. Now, when I receive the shares of ABFRL against TCNS Clothing shares, because this merger is otherwise tax neutral, I don't really pay any tax at the time of receiving ABFRL shares. It's essentially share for share, which is one of the key compliance conditions of a tax neutral merger, and therefore, per se, on the merger, I don't really pay any tax as a shareholder of TCNS. However, what is important going forward is to see whether the grandfathering benefit that I could have enjoyed as a shareholder of TCNS because of its fair market value of 2018, would that be really available to in relation to the shares of ABFRL which I have received in consideration of TCNS Clothing, which otherwise enjoyed this benefit. Unfortunately, while the law does contemplate certain situations where a grandfathering benefit is, for want of a better word, grandfather, this particular fact, however, does not find an express mention in the income tax law, and therefore there is no clear guidance available under the income tax law about what would happen to the cost basis of TCNS shareholders in relation to ABFRL shares. So that is one important distinction that shareholders would need to keep in mind in similar situations possibly going forward, where they are at a crossroads of whether to tender the shares or not. Of course, when we talk about amalgamation and tax neutrality, again, the conditions that we spoke about earlier about potential losses, entitlements, from a tax perspective, moving to the amalgamated company, all of those aspects continue to be relevant even while examining a merger of this fashion between two listed companies.
So to sum it up on this, the bundle of announcement, if you were to call, I would say it gives a clear clarity to the market on the full plan of both the companies. It gives immediate control with compliant exit to public shareholders via open offer, and a clear medium-term pathway to consolidation through merger. It and it one would also say that it also helps to align stakeholder expectations, including employees, lenders, vendors, on the end state from the day zero, if you were to we were to say that. In summary, if I were to look at SPA plus open offer plus long stop merger with control shifting early and consolidation happening later, I think it was a fantastic structure, and while it had its own difficulties, but it was it is a very good structure to take away at the end of the day. Next slide.
Thanks, Mehul and Jimmy. This is very interesting and very educational. I definitely learned a few things myself. We've been getting a lot of questions from the audience through the chat window. Let me just lob a few at you. Uh, I think one, Mehul, is you mentioned the time gap, right, between the 12 to 15-month time gap that you typically see in a transaction, especially in a scheme of arrangement. What protections do minority shareholders typically rely on during this intermediary period?
Kapish, one is generally that the companies are operated by their boards. So both the companies, while you have a shareholder, you have a promoter. But at the end of the day, you do have the committee of independent directors. You've got independent directors on board, and you also have a management which is while the promoter comes in, but the management continues to be the same, and it continues to operate in the best practices which are generally followed. As I also mentioned that the auditors are still there, the independent directors are still there, and therefore related party transactions, etc., all are being undertaken by way of best governance practices to that extent.
Correct. Understood. Thanks. That's clear. Let me just pull out anything else. This one was a doozy. Maybe this is more for Jimmy. So the question is, in the Ajmera transaction that you stated, right, where there was a demerged company and a resultant company, the participants asking that if in Ajmera had accumulated business losses and unabsorbed depreciation, whether that would have been allowed to be carried forward by Radharaman, which was the undertaking that is demerged to.
Sure. Yeah, this is an interesting one, and all the more in cases such as this, where Ajmera also ends up becoming one of the resulting companies. So when we look at the tax provisions relating to carry forward of losses in case of certain demergers, essentially the law states that, look, to the extent a loss relates to a particular undertaking and that undertaking is being demerged, the loss should necessarily transition to the resulting company. And I think a very intelligent question in that context, that what Ajmera is also a resulting company. So do I even transfer or not? The way we would like to look at it is that, see, fundamentally, what do we mean by according a loss carry forward to the resulting company? Essentially, we mean that, look, for whatever reasons, there were losses by carrying out a business in the demerged company, and we want to ensure that the business continues going forward, and therefore we don't want to disentitle the receiver of this business from claiming a set off of such losses going forward. Plainly basis this principle, clearly the losses of Ajmera relating to this undertaking, if they did exist, then one would like to believe that once they are transferred to Radharaman Ventures Private Limited in the form of the undertaking, the losses naturally, spiritually and necessarily and logically belong to Radharaman, because they are the ones who are ideally, in a, so to speak, going to turn around the business. And if they are, earn profits, then necessarily the losses of the past should also be available to them going forward from income tax, corporate tax payment.
And but this is still a gray area, or this is like a settled principle for you?
I think as Mehul mentioned earlier, in fact, the scheme such as the Tata Coffee scheme itself is not common, and the Ajmera scheme as we speak is, I can very well by and large say, that is one of a kind so far. Very few instances other than Ajmera itself. So clearly, so for this principle to get tested, I mean, one would need first of all a case study such as this, which also has losses on top of that. So I think a lot of stars will have to align for such facts to really emerge in before courts or before any assessment authority.
Got it. So the truth, maybe the participant is planning that, right? Maybe that's why it's such a pointed question, and we're hoping to see this in the market soon.
Absolutely. More than happy to issue an opinion, yeah, and examine it.
Okay. Mehul, you mentioned in one of your in the first structure about stamp duty of ad valorem versus conveyance deed. I think there was a follow-up question on that, and I think one of the participants wants to know is what are the stamp duties on these structures, and maybe you and Jimmy can tag along and tell us what's a typical stamp duty that you would see in a merger and acquisition in a like-to-like situation.
So, see, generally, if you were to look at stamp duties are a state-specific law, and therefore the Constitution provides for it, and therefore each state is entitled to impose stamp duty as per the law that it has framed. It's a revenue for that state, and therefore the law has evolved in few years, and every state has realized that it's a good source, easy source of revenue for them, and therefore while there are provisions under the each state stamp laws of giving remissions or giving set-offs for stamp duty which has been paid in other states in relation to the property which is based out in their jurisdiction. But more often than not, we've realized that you end up paying stamp duty in each state unless and until you have the appetite to litigate further. But to come back to the stamp duty, like you were to look at Maharashtra, the stamp duty is like 5%. Generally, a conveyance is 6% or 5% plus 1% that you have with you paying cess on it. But the stamp duty, if you were to transfer it under the scheme, you've got a cap which is like 50 crores and 0.7% of value of shares issued. So it's not ad valorem. It is capped. You have something similar in Gujarat. You've got something similar in Rajasthan. You've got something similar in Andhra Pradesh, in MP. A lot of states have a cap. You've got Haryana as well, which is the lowest amongst all which you see. Bangalore, Karnataka is again 25 crores, but Haryana you've got a 7.5 crore cap. So a lot of these jurisdictions, you have a consistent stamp duty when it comes to schemes, and something similar if one were to, and therefore if say I would do a Ajmera, or if I were to do say I would have done a Tata Coffee folding into consumer and then bringing back into a separate company, you would have ended up paying stamp duty twice. One for the merger, taking the immovable properties at the top, and then bringing the same business down below. Not only from a stamp duty perspective, but also tax, if any. If I were to do a slum sale, then or if I were to do a tax, a transfer, a tax neutral transfer, definitely no tax. But again, a stamp duty would be to that effect.
Clear. That's very helpful, and especially on the stamp duty save. That's something I had not thought about. That you actually end up saving stamp duty in the Tata Coffee structure, and that's an interesting point. I have something else as well, and this is actually a question that even I had, and one of our participants asking that in the case of acquirer already holding a stake, and honestly, I had also taken a note of that. In, for example, your TCNS structure, ABFRL had picked up a stake in TCNS, so it was also a shareholder as well as the party to the merger. In that situation, how are the swap ratios and valuation calculated?
Uh, See again, it's more of a valuation question, Kapesh. So valuers would have done the valuation exercise there. But generally, what would happen is on the date when the transaction would have got announced, one would have undertaken the value of the business because there's no fresh investment coming in either of the companies. So there was an open offer, and it was and so it was a share purchase coupled with the open offer. So at the end of the day, you are only issuing shares to the shareholders to the extent of the value that it holds. So TCNS would have been valued on a standalone basis, depending on the multiple methodologies like DCF or the income approach that you say, market approach, having the multiples, or there's some people, the business which others are into similar nature. And I don't know whether the asset approach is not generally which is applied in in a merger or a company which is not heavy with assets, so or not a asset heavy company. So generally they would have applied this test for respective companies and then determined the share swap on merger.
Yeah, but then basically the shareholders already get the shareholders of ABFR in this situation would get the benefit of their shareholding, right? So it's basically the
They
shares
would,
would
they
get
would,
cancelled.
they would, na? They because the company is folding into them, so the dilution
Hmm.
of ABFRL is only to the extent of assume for a moment, if it was a situation where you would issue shares to everybody, so the dilution of existing shareholders would have got diluted to the extent of 100%. Here, the
Correct.
dilution got to the extent of, I think, 52% post the open offer. They held about 52%. ABFR held about 52% in TCNS. And post dilution, so dilution was only to the extent of 48% that the public shareholders held in TCNS.
Yeah. So in this structure, at least the way I see it is TCNS shareholders were better off because they had the option of cashing out through the MTO or sticking around for the final entity, and the Aditya Birla shareholders had the benefit of not getting diluted to the extent of the full acquisition, and that acquisition would have cancelled off their shares. So both
Correct.
shareholders were out.
That's right. I agree to that.
Okay. One more. I had one more tax question, maybe for Jimmy. TCNS was listed prior to the merger. What happens to its historical tax losses or credits during the transition during the merged entity? I like the fact that Jimmy's getting all the easy questions from our tax professionals.
Not so easy, but yeah. So see, I mean, my initial reaction would have been that you know what, it's unlikely that if you are a listed company that you would have tax losses as well. But I mean, we are living in different times, and we are seeing more and more companies with different models also having tax losses uh, or losses in their P&L as well, despite being listed. So from an income tax perspective, of course, there is a section 72A, which deals with companies in relation to which losses can really transfer to the amalgamated company. It only has a specific set of sectors which are listed there. One is that look, it should be an industrial undertaking which should be carried out by the amalgamating company. An industrial undertaking generally falls in a category where there are any manufacturing operations here which are undertaken in the amalgamating company. So if we were to kind of proceed with a reasonable assumption that TCNS was not just a retailer of clothing but also a manufacturer and seller, the law does allow carry forward of such losses, but only for the unexpired period going forward. Uh, that too, of course, is subject to conditions relating to maintenance of certain de minimis level of fixed assets at TCNS level itself prior to merger, and also continuation of maintenance of a certain threshold of such assets post merger by ABFRL. Uh, the law also requires certain minimum maintenance of manufacturing capacity pre and post merger, essentially, and fundamentally as an anti-abuse mechanism to essentially ensure that look, the merger was not undertaken only to kind of take benefits of losses from a tax perspective, but also indeed to really revive the operations or turn around the operations of the manufacturing capacity which the amalgamating company had in the first place.
Yeah.
Yeah.
Thanks. That was helpful. I'm like, yeah, these are definitely not easy ones, but glad that you could feel these. I'm also aware of the time. I think we extended beyond the time, but I'm going to indulge a little bit more and keep you guys with me for a few more minutes. If anybody else has questions, please drop them in the chat box now. I'll get Mehul and Jimmy to email you the answers separately. But I'll just wrap up with this last question, which is very dear to my heart as well. Uh, Mehul, what happens if the merger is delayed or does not complete after control is acquired?
If the merger is delayed, the companies continue to operate as independent companies. It would be really tough on the strategies, etc., to be framed going forward. But the parties will have to run as if these were two companies never connected to each other. the boards of respective companies will have to take care that there is no breach or violation of corporate governance or related party transactions, etc. To that effect.
Yeah, so it's a tough one then if you're stuck there.
It's a tough one. So and we know for a fact there are a few companies where things into similar nature of business. It is tough to manage, operate when the idea of acquisition itself, or the intent at the time of acquisition itself, is to see that we leverage both the companies' resources, we bring out the synergies of both the companies together, and create a better environment for, or a better company or shareholder value creation for the shareholders of both the companies. And when that gets delayed, I think that delay is for some months. It's not years. It's few months here and there to that effect.
Yeah, so
But I
good
don't.
understanding.
I can tell you here, I don't know a company which where a majority of minority was rejected, and the shareholders, especially the minority shareholders who rejected, faced a huge value depreciation, decrease in value when the consolidation could not take place in time. So there are illustrations as well, examples as well to that effect.
Sure. Helpful. I was just going to pitch it. I'm saying that if you want to mitigate delays, you come to Mehul. He'll plan it better for you. But yeah, it's something that is beyond anyone's control. Sometimes these things do happen, and you should factor that into your M&A transaction. As the moderator for today, I think one of the only responsibilities I have is to identify a few key takeaways. So let me do that now. I think thanks, Jimmy and Mehul, was very helpful. I think for me, the key takeaway on this presentation or the webinar is that schemes are no longer antiquated past. While they've been with us for a lot of years, people are now using them very efficiently and very effectively, especially to for tax planning purposes. And the benefits that the schemes give on taxation are so unparalleled. We are seeing them extensively used in M&A in more and more unique ways. Right? We looked at two examples. One is for an internal group restructuring, and one was a third-party acquisition. Both case studies used schemes very effectively to optimize a internal reorganization as well as the taxation of the deal. So it's no longer something that we don't think about. On almost every M&A transaction, we have Mehul, his team, and Jimmy involved to sort of try and see if there's a way to do a code scheme, to do a scheme through there, use them for more and more innovative and effective purposes. So please get in touch if you guys are looking at a scheme, and we'll tell you how more cutting edge. I think this is no longer cutting edge for Mehul. This is already out in the public. He has some other aces up his sleeve. Jimmy and I are also working on something there. So that envelope is keeping on getting pushed. Uh, I hope our audience enjoyed each one of these excellent presentations as much as I did. I definitely learned a lot. I hope everybody else here did as well. Thanks for everyone who participated in the poll and on the webinar. And finally, I would like to thank our presenters for sharing their expertise and experience with us today. Simply outstanding. Thank you so much. Each and every audience member here, thank you for taking out your valuable time and attending, whether it's as part of the live webinar or as a recording thereafter. Our contact information is on the screen, so feel free to reach out to us if you have any further questions or if you need any other further clarifications. As a reminder, we will be sending you a copy of this webinar's presentation, a summary, and any answers to your questions that you have raised separately. If you're interested in any training or any other matters, please feel free to reach out to us, and we're typically available on these email IDs. Thank you so much for your attendance today, and we look forward to seeing you in our next M&A program. We have a few lined up, and excited for the year ahead.